The governors are for each state, the governor has to be present. We have learned something about the powers of that governor. Then how the governor is appointed, we have seen, and what are the term of the governor. That is a maximum of 5 years. He can serve his duty, and after that, what are the qualifications which are required for the appointment of the governor? We have seen the first and foremost case for the qualification of the governor is he should be a citizen of India, and just see the age group, that is he, uh, he should have completed of 35 years. Okay, and conditions of the governor's office, that is it consists of two houses, that is House of the Parliament and also the House of the Legislature. So that's what we have learned, and some powers of the governors we have studied, and depending on that, it is divided into two types, that is two assemblies, that is Legislative Council and Legislative Assembly. Okay. Um, so some of the states are having both the houses, that is Legislative Council and Legislative Assembly, and some of the states have only the Legislative Assembly as the only one house. Okay, so that Legislative Assembly is also called as Vidhan Sabha. So we have seen how the Vidhan Sabha members are elected, and how many numbers are there, and depending on that some acts we have seen, and the main what are the qualifications to become a Vidhan Sabha member we have seen. Okay, and what are his powers, and also some of its functions, how the bills are passed, and how much maximum time if the governor doesn't allows the bill, then how much time it has to be within that, and depending on that we have seen in the last class, and also we have seen about Legislative Council. It is also called as Vidhan Parishad, and in that Vidhan Parishad the MLCs are elected, and what are the terms for that MLCs, and how they are elected, those all we have seen, and something about the high court system we have seen, how the judges are appointed, and how the lower lawyers are appointed, and all those things we have seen in the previous class, and depending on that some clauses, also some functions about that we have seen. Okay, so now moving further, so now today we shall see about the electoral process in India now. Okay, so what do you mean by that electoral process? According to the Constitution, Parliament has enacted the Representation of the People Acts of 1950 and 1951 to prescribe the mode of election. Okay, so the Delimitation Commission Act of 1962 and 1972 for the delimitation of constituencies for the election. So what do you mean by that delimitation of constituencies? So let us see over there now. So delimitation of constituencies is done by the Delimitation Commission appointed by the President. Okay, so after every census. So decision is final and cannot be changed by any court. Okay, so in that electoral process, it consists of two things, that is delimitation of constituencies. So that the members which are there in that constituencies are appointed by the President only, and whatever the decisions from that thing they have taken, those decisions are final, and whatever the decisions they have taken, it can't be changed by any court now. Okay, so notification of election now. So everyone knows how the election process is carried out. The first and foremost thing is first they will announce the elections, that is nothing but a notification of the election now. Okay, so election notification issued by the President of India for election of Lok Sabha. Election notification issued by Governor of State for the election of Legislative Assembly. Okay, so the election notification which is issued by the President is with respect to Lok Sabha. The election notification which is issued by the Governor, it is with respect to Legislative Assembly. Okay, so don't get confused between the two notifications. That is, one is the election notification which is issued by the President of India it comes under the Lok Sabha. Okay, and another one election notification which is issued by the governor, it comes under the Legislative Assembly. Okay. So now, notification by the Election Commission regarding nominations and withdrawal. What are the step-by-step procedures for the conduction of the elections are? So first and foremost thing is they announces the dates for filing of nomination and withdrawal. So first thing is they announces the dates. Then next, after the announcement of the dates, the candidates have to fill their nomination papers. So those who want to participate in that election process, that is candidates, they have to fill those nomination papers. Next, candidates belonging to the political parties should submit B form. Okay, so one B form will be there. They have to submit that B form issued by their party. Okay, so the election deposit for Lok Sabha is 10,000 rupees. So if a person wants to want to participate in the Lok Sabha election, that person has to deposit 10,000 rupees. Okay, so if the person wants to constitute for a legislative assembly, then he has to deposit 5,000 rupees. Okay, next, the candidates belonging to the lower caste, that is SC and STs, election deposit for Lok Sabha is 5,000 rupees, and the election deposit for legislative assembly is 2,500. If the candidate comes under normal categories except SCs and STs, for Lok Sabha election he has to pay 10,000 rupees for nomination, and for legislative assembly he has to pay 5,000 rupees. If a candidate belongs to SC and ST, for Lok Sabha election he has to deposit 5,000 rupees, and to constitute for the legislative assembly he has to deposit 2,500 rupees. Next, election deposit will be returned if the candidates secure more than 1/6 of the total votes. So please see over there, whatever the deposited amount they have given to for the nomination processes, if that candidate or that person gets a vote of 1/6 of the total votes, then whatever the amount he has given, that is 10,000, 5,000, or for the other cases for 5,000, 2,500, whatever the amount he has given, that amount will be returned back when 1/6 of if he secures 1/6 of the total votes polled by his constituency, then only he will be able to get all the amount whatever he has given for the nomination processes. So I think it is clear how the process goes on for the Lok Sabha and Legislative Assembly candidates. Okay. Next, verification and acceptance or rejection of nomination papers. So there may be a chances that his papers may be rejected. So before that rejection, the president has to undergo. He has to verify the nomination papers. If it is correct, then he can accept those papers. Otherwise, if he finds any defects in that paper, then that nomination paper will be rejected. So let us see what are those conditions so that the president can go through those nomination papers. So the Election Commission verifies the nomination papers and accepts which are in order and rejects which are not in order. So whatever the nomination papers which are submitted by the candidates, those papers are verified by the election commissions. Okay, so if the papers are correct, then and they are placed in orders, then they are accepted. Otherwise, there may be a chances of rejection of those nomination papers. After that, if the candidates get selected, then they announces the names of the candidates. Then after that, if the name get announces, then your campaigning starts. Then so everyone has gone through this campaigning processes. Whenever the elections are nearby, each and every parties undergo this election campaigning. So that election campaigning has also got certain days, like he all through the years or all through the month he cannot do the campaigning. So what is that minimum period he can do a campaigning is, period of election campaigning is only 14 days. Okay, so after 14 days he cannot do his campaigning. Campaigning should be stopped before 36 hours from the date of election. So please make a note of that. That is, the person can, or the candidate, after his selection, the candidate can campaign his campaign his party only for about 14 days, and before 36 hours of the date of election he has to stop his campaigning. Okay, next, after the campaigning, next comes is the polling processes. That means where the votes are being put. Next, so in that polling process, we can see that takes place on a fixed date and a fixed place. So how the votings are done? Some voting machines are kept. So everyone, so who and all belongs to the citizen of India. The election card will be issued for the normal public based on the election cards. Those people which are at fixed, they will find their names at particular booth, and those person will go and vote to their respective parties. Then next, after voting, what will come? That is counting and announcement of election. So election commission announces the names of the successful candidates. That means if a person gets a higher number of votes, then we can say that that party has won the election. So who announces those candidate name is the election commission. So the certificate will be issued to confirm. So in that article 324 of Constitution for the establishment of the Election Commission of India. Next is controls over the elections of the President, Vice President, Lok Sabha and Legislative Assembly. An independent body like Supreme Court of India performs its functions freely without influence and interference of the political parties and executives. Election Commission of India constitute of a Chief Election Commissioner and other 2 election commissioners. So these all are responsible for the counting and announcement of the elections. That is Election Commission, Chief Election Commissioner and other 2 election commissioners. The President may increase the number of election commissioners if the voting is if the number of votes are very huge in number, then the President has all the powers to increase the election commissioners. President in Constitution of Electoral Commission appoints the regional commissioners for each state. The term of office of the election commissioners are determined under the Act of the Parliament, which came into force on 25th Jan 1991. So whatever that Act of Parliament is there, so it has come into picture on the date 25th Jan 1991. So what that Act of Parliament says? So it holds the office for a term of 6 years. So if a particular party, for example, if you say a BJP, Congress, Janata Dal or whatever it is, so many parties are there. So depending on that, the election takes place, and one of the party will win the election. So after that, after winning the election, that party comes under the Act of Parliament Act. So that was formed in the year 1991. So which party has won the election? He has to undergo all the conditions. That is, first condition is what? That party has to be their term of their ruling will be 6 years. Then retirement age of the election commissioners is 65 years. Okay. Preparation of electoral rolls, revision of electoral rolls, allotment of seats, conduct of elections, granting of recognition to political parties, allotment of symbols, ensuring fair and free elections. So these all the points will come under the Act of Parliament. Next, amendment. So what do you mean by amendment? Amendment is a statement that is added to or revises or improves a proposal or a document. Okay. So if one document is there, if you want to revise it or if you want to add some more points to that document, then it is called as amendment. Amendments of the Indian Constitution have been done for the purpose of variation, addition or cancellation of any provision made in the Constitution. Since the enactment of the Constitution of India on 26th November 1949, there have been 94 amendments made to it till 2006. Number of bills are introduced before Lok Sabha and Rajya Sabha for further improving of the Constitution. So, if for the further improvement of the Constitution, so you can see that amendment, this thing has come into picture on 26th November 1949, and up to 2006, 94 amendments have been formed. That is revised. One amendment, one document will be there, and based on the different revisions, that is based on the different political parties, whichever the party which has won the election, some changes they will do. Okay, so from 1949 to 2006, 94 such changes have been done. So it is called as 94 amendments up to 2006. Okay. Next, constitutional provisions for amendment of Indian Constitution. So part 20 of the Constitution of India deals with the amendment of the Constitution. So in that amendment, some part 20 is there. So in that it deals with the amendment of the Constitution. The Article 368 specifies the power of the Parliament to amend the Constitution and the procedure of it. It is also mentioned in the article that there will be no limitations on the constituent powers of the Parliament for amending it by adding, removing or improving the provision made in it. Okay. So now, how the amendment works. So we shall see how the procedure for the amendment of the Indian Constitution. The method of an amendment to the Constitution is considered to be highly complicated procedure. So it is not at all very easy to change the amendments. Okay. So amendment can be made by various methods which have been modeled based on the South African Constitution. So whatever the amendments they have prepared. So maximum points have been taken from the South African Constitution. The initial step of an amendment of the Constitution is the introduction of the bills. The first and foremost thing is what in that amendment? First is that introduction of the bills regarding it in any one of the houses of the Parliament. So you have seen two houses. One is Lok Sabha, another one is Rajya Sabha. Okay. The bills can be passed by a simple majority of the Parliament. Before sending the bills, the President assesses there can be a voting among the members of the Parliament present. If majority of them votes in a favor of the amendments, then it is accepted. Otherwise, the President has got all the power to reject that amendment. An amendment can be can also be finalized. So one more condition is there. It can be also if maximum number of voters rejects that amendment. One more condition is there. What is that condition? Amendment can be also finalized if 2/3 of the members of the Parliament present vote in its favor. Then only the amendment can be passed. However, the number of voters should be more than half of the total number of members in the House. This method is known as special majority of the Parliament. Okay, so please be careful in that reading these things. That is, first thing is what the bill can be passed by a simple majority of the Parliament. So before sending the bills for the President access, there can be a voting among the members of the Parliament present. Okay. So if majority of them votes in the favor of amendment, then it is accepted. If suppose, if it is not accepted, then it can be also finalized if 2/3 of the members of the parliament present vote in its favor. However, the number of voters should be more than half of the total number of members in the house. Okay, so whatever that method is there, that is two types. It is called as what? Special majority of the parliament. In some cases, bills for amendments to the Indian Constitution finalized in this method may also require ratification of the legislature of at least half of the Indian states. Okay, so now, so we shall see which are those amendments and which have been modified. Okay, so as I have told you all, the amendment has been started in the year 1949. So next it got changed in 1972. It is the Constitution Act 1972. It is also called as 42nd amendments. So many amendments are there, but only few amendments are listed over here, which are very important and which have changed. So many changes are taken place in a certain amendment. Only those things have been listed in this in this presentations. Okay. So 42nd amendment. So it is also called as Constitution Act 1972. So firstly, it changed the characterization of India to sovereign, socialist, secular, democratic republic from sovereign, democratic republic. Okay. So what it has changed in that amendment in the 1972, sovereign, socialist, secular, democratic republic from sovereign, democratic republic. Okay. This is the first change they have done. And in the second this thing they have done what? The words unity of nation was changed to unity and integrity of the nation. So this is the second change they have done. In the third change, what we can see, the fixation of the numbers of the seats for scheduled constitutional amendments and the scheduled tribes in the Lok Sabha and legislative assemblies was also frozen. That means no addition of extra numbers in the Lok Sabha and the state legislative. They have fixed the number of candidates in the Lok Sabha and state legislative assemblies. So that is the third change they have done. And one more change is the quorum in the House of the Parliament or the state legislature was left to be fixed by the rules of each house. Okay. So these are the some major changes which have been done in the 42nd Amendment Act. So next major change they have constituted is the 44th Amendment, that is called as Constitution Act of 1978. So this amendment brought a lot of changes in many articles. The preventive intention for the period of more than 2 months can be ordered only on the recommendations of the advisory board. The right to property was omitted as a fundamental right and made it as legal right. So this is the major change they have done in the 44th Amendment. What they have done, whatever the right to property act is there, so that act they have removed it and they have made a legal right. That means right to property was made compulsory. Everyone have got all the rights. Okay, but minorities will have rights to establish or run their educational institutions as before. So next, coming to one more act, that is 74th Amendment Act. So when is that 74th Amendment took place? It took place in the year 1992. Okay. So so what changes they have done in that 1992 Act? To ensure effective functioning of the urban local bodies, a new part, that is 9A, part 9A, relating to the so in that part 9A, it comes so which and all comes under is municipalities, nagar panchayat. So those comes under that part 9 in the amendment that they have changed. Okay. So part A relating to municipalities and nagar panchayats for areas in the transitions from a rural area to urban area, municipal councils for a smaller urban areas, and municipal corporations for larger urban areas. So what they have done, they have changed the things, that is from a rural area they have the rural area they have converted to urban areas, and municipal councils for smaller urban areas and municipal corporation for larger urban areas. Okay, so that there won't be any more hectic works should be present in a smaller areas. Next, one more act, that is in the 76th amendment, again some changes have been made. So that took place in the year 1994. So this amendment places the Tamil Nadu Bill of Reservation with the preview of the 9th schedule to the constitution. So what does it say? The government of Tamil Nadu reserves 18% to scheduled caste, 1% to scheduled tribes, and 50% to other backward castes. So totally 69% they have reserved for all different types of categories in the educational institutions and public employments. Okay, so till now, that is up to 76th, before 76th Amendment Act, this condition was not there. Okay, so rest all conditions are present in the 76th Act also, but what new things they have introduced, just I am going through that now. So in that 76th Amendment Act, the major change what they have done is they have given reservations. For scheduled castes, they have given reservations for 18%, for scheduled tribes 1%, and 50% for other backward classes. So in totally it is going to be 69% in the educational institutions and also for the public employments. Next act which got a major changes is the 86th Amendment Act, which took place in the year 2002. So this act may be called as the Constitution, that is 86th Amendment Act 2002. So insertion of a new Article 21A. So one new article they have introduced, that is Article 21A. So in that Article 21A, what it specifies is right to education. Each and every child has got a right to education. So that compulsory education was made in the 86th Amendment Act, that is in the year 2002. The state shall provide a free and compulsory education to all the children of the age of 6 to 14 years. Okay, so who and all comes under the age of 6 to 4, below after 6 years, the education has to be, the minimum education has to be made compulsory for all the children. So that act came in the year 2002. Next, provision of early childhood care and education to law children below the age of 6 years. That's what I have told in the second point, that is below the age of childhood care and education has to be provided for all the children. So the amendment of Article 51A. In Article 51A of Constitution, after clause, the following clause shall be added, namely, K, who is a parent of a guardian, to provide opportunity for education to his child, or as a case may be ward between the age of 6 and 14 years. So no children will be allowed to work below 14 years. So that act, that means below 14 years, everyone has the right to be educated. So that act made compulsory in the year 2002, that is 86th Amendment Act. Okay. Next, after that, the 91st Amendment Act, that is, it took place in the year 2003. So what major changes they have done is, this act may be called as the Constitution 91st Amendment Act in the year 2003. So in that, the Article 75 of the Constitution, after clause 1, the following clauses shall be inserted, namely 1A, that is 75 Act is there. Okay, in that 75 article 75 1A is introduced. So what is that 1A specifies? The total number of ministers, including the Prime Minister, in the Council of the Ministers shall not exceed 15%. So okay, so the which and all ministers are there in the council, they should not exceed 15%. So again, in that Article 75 1B, so three these things are there. 1B, a member of either houses of the parliament belonging to any political party who is disqualified for being a member of that house shall also be disqualified to be appointed as a minister under the clause 1. Okay. The total number of ministers, including the chief minister in the council of ministers in the state, shall not exceed 15%. That's what I have told in the 1A also, of the total number of members of the legislative assembly of that state, provided that the number of ministers, including the chief minister in the state, shall not be less than 12. Okay. So in the 10th schedule of the constitution, in paragraph 1 in clause B, the words and figure paragraph 3 as the case may be shall be omitted. So B, in a paragraph 2, in sub paragraph 1 for the words and figure paragraph 3, 4, 5, the words and figures paragraph 4, 5, 5 shall be substituted. So whatever that this thing is there in the 91st Amendment Act, some changes they have done. That's what they have explained it over here. Okay. So in this Constitution of India, you will be having some important things I have discussed over here. So regarding based on the syllabus, whatever you have. So in that you will be having two major criteria. That is, one is based on the governors, and also some governors, his powers and all, and high courts and some amendments. Okay, so I think this is I think only these things are there with respect to your syllabus. So notes and also this presentation will be shared in your respective WhatsApp group by your concerned faculties, and also this you can see the videos in your okay. So I think I have finished with the portion. Okay. Thank you.